Hello, everyone. Thank you so much for attending today's webinar. My name is Hannah Whaley, and I'm the Senior Business Immigration Attorney here at Egan Immigration. And today we're super happy to provide this presentation to you guys, where we will be covering the Powerhouse visas known as the H-1B, H-2A, and H-2B visa. Now, along this presentation, please feel free to drop any questions that you have in the chat because we will be reaching out after to answer these questions directly. But if you have any questions, again, remember to drop them in the chat. So today, what we will be covering is the H-2A, H-2B, and H-1B visa. But specifically, what we will be learning is how do I qualify? How do I apply? How do I go about filing these visas? What are the processing times and important aspects that are necessary to understanding how to qualify for these visas and successfully obtain one? So what are the Powerhouse visas? The H-1B and H-2A and H-2B are commonly known as the Powerhouse visas because they are the most commonly used temporary work visas that are used here in the United States. Now, the H-2A is the first visa that we'll cover, and this is a temporary non-immigrant visa that's specifically for workers who are within the field of agriculture. And what this visa allows, it allows employers who anticipate a shortage of domestic work to bring foreign workers here to the United States to perform temporary or seasonal agricultural work. And some of the most common occupations within the H-2A category include various different types of farmers, including crop farmers, animal farmers, as well as agriculture equipment workers, construction workers, truck workers, graders, and sorters, as well as supervisors. However, this is not an exhaustive list. There is a wide variety of jobs and occupations that fall within the category of H-2A. So how do you qualify? So the first thing is that it must be temporary or seasonal in nature. And this is a very important aspect to focus on because the H-2A timeline for this agricultural work must be a year or less to fulfill that temporary nature. Next, an employer must show that there are not enough U.S. workers who are able, willing, and qualified to do this temporary work. And there is a way that they do this through prevailing wage and recruitment that we'll get to in a second, but they must demonstrate this. As well, it is very important that the employer shows that hiring H-2A workers does not adversely affect the wages and working conditions of their similarly employed U.S. workers that they have. So how do you obtain an H-2A? So the first thing you have to do is obtain a prevailing wage determination. And what this does is it provides an employer with a minimum amount that they must pay their H-2A worker. And again, this is a minimum, but it is required for the Department of Labor process, which is this beginning portion. Next, you have to file for a job order for the H-2A. In a job order, specifically, it's a SWA order, and that's a job order that you file with your state workforce agency. And with this job order, it essentially is an advertisement to your area and for the state showing that that job is available. And the job order is something that you should pay lots of attention to because there are a lot of requirements and standards that go into that, and it can affect your ability to be approved in this initial portion. As well, at the same time, you're also filing this application for temporary employment certification. And what happens is you take all of these things and you submit it to the Department of Labor, who reviews it as well as your job order to make sure that it is correct and within the regulations. And at that point, they will send you an approval denial RFI requesting more information, and you will be able to start conducting recruitment. Recruitment is specifically where an employer has to go through certain advertisement options of showing and giving the US workers a chance to apply for this job. And this is in various ways, such as the SWA job order, online posting, notice of filing, many other things. Now, in this fifth step, what is going to happen is that the employer takes all of these things together and compiles something called a recruitment report, which is required by law to have. And this recruitment report essentially shows if anyone applied for the job, what that process was like, if someone was denied, why were they denied? And you take all of this and you submit it to the Department of Labor. And this is because they want to see, did you truly, as an employer, give the US market a chance? Did you give each person who applied a true, fair, and accurate chance to have this job? Were they qualified? And ensure that we're not essentially shortcutting US workers to take advantage of foreign work. Now, after that, you will get a final determination notice granting approval or denial. And once you have your approval, the great thing is we are done with the first part with the Department of Labor. So now all that we have to do is file with USCIS. So the second step is you're taking all of these things and you're filling out and submitting the form I-129 for temporary labor certification and additional documentation. All of that together, you submit to USCIS and they will approve it. And H-2A workers outside the US will apply with the Department of State at an embassy or consulate abroad. But that is the entire H-2A process. And it genuinely is more of three phases of that Department of Labor, USCIS, and then we have that consulate and embassy portion if the individual is outside of the United States. And this is, again, just a quicker look at the process from a bird's eye view. First, you obtain that prevailing wage determination from the Department of Labor. Next, you're going to file that job order and that application. NPC in Chicago, that's with the Department of Labor. Everything's going to be reviewed and you'll receive it back within 7 days. The next step is you get that approval or that deficiency notice and you start going into recruitment. And when you get this notice of acceptance, it does specify when recruitment needs to happen. So after that recruitment step, what's going to happen is the NPC reviews it. And that's when you get that approval or denial on that final determination. And then you're able to move forward with filing with USCIS. Now, here are the important aspects of the H-2A. The first thing is that job order compliance is essential. Officers look very closely at this. And this is, again, because every piece of recruitment, not just the SWA job order, there are very specific requirements that have to be in there, such as the employer's name, the salary, the specific requirements, education. Everything needs to, in a sense, mirror that prevailing wage document. And officers look very closely, as small as things as misspellings, they would say could affect it because it's substantially affecting the chance of other people being able to get this job. So it's essential to make sure that your job order is correct and looks really good. Next is that H-2A employers must provide housing at no cost to H-2A workers. And this is something that is unique to the H-2A, but it is important due to the nature of the agricultural work that is usually associated with it. Next is employers must provide 3 meals a day to employees or free and convenient cooking and kitchen facilities. And if that is not the case and the employer is going to charge meals, the max at this point that an employer can charge is $15.46 per day. What that means is anything that goes past that, the employer cannot charge the individual employee for if they're not able to provide free and convenient cooking facilities to their H-2A workers. Next is the H-2B, and the H-2B essentially mirrors the H-2A in form. The difference is that the H-2B is specifically for temporary work that is non-agricultural. And again, if you have any questions, be sure to drop them in the chat because we will get back to you. But the H-2B mirrors it. The H-2A is just agricultural, and the H-2B is everything else that isn't associated with agriculture. So here, to qualify for the H-2B, the big thing in this specific area is showing that there is a temporary need. But here with the H-2B, there are very specific categories that you have to fall into in order to show this temporary need. As well, it cannot be for the purpose of fulfilling a permanent or indefinite position. A perfect example of this is if you own a business and let's say the general manager, that is a very permanent position. You cannot use the H-2B to temporarily fill the general management position because a USCIS officer is going to say that that position is a permanent role and you cannot utilize the H-2B for that, because the goal, again, for these visas that we're speaking of today is temporary work, and that the nature of it is very temporary, not to fulfill a permanent position in due time. Now, what does USCIS consider when looking at the H-2B? First thing they look at is the timing. Although the H-2B can have the validity period of 3 years, it is generally limited to a year or less. And that's because you have to show with a specific event, let's say you need 3 years on an H-2B, it's usually harder to show that something is so temporary in nature to extend to that period of time. Can it be done? Yes. But generally, for the H-2Bs, you want to limit it to a year or less. 10 months is typically the sweet spot that we see with H-2Bs. The next thing that we're going to look at is what duties will the worker perform and whether the need extends throughout that employment period. That is very important for the H-2B as well, because if you're requesting an employee for a year, you need to be able to demonstrate to USCIS that this is a need that actually will consistently continue and that isn't limited to a specific part of the year or it's for a specific event. Now, these are the categories that I was speaking of when I was talking about the nature of the work. Now, the first two categories that we can fall into is a one-time occurrence or a seasonal need. One-time occurrence is where an employer can show that there is a very singular event or project. Let's say a great example would be, even though this would be more agricultural, but if there was an apartment complex that needed to be built, that is a perfect situation where an employer can show that once the apartment complex is built, the purpose and work of the employee no longer continues. That's what you want to see with that one-time occurrence, something that is very specific and limited to specific parameters, so to speak. Now, with the seasonal need, this is where an employer must show that their services and labor are tied to a season or a pattern or a specific event. A perfect example of this is when we see, now that we're in the holiday season, you see the Halloween stores popping up, Halloween Express. These aren't stores that typically last all year, or even some of the Christmas stores and Christmas tree companies that we see start to pop up in the holiday season. Those companies would be perfect employers for the H-2B because they're able to show that their business is tied to specific holiday seasons. Therefore, they're able to show the seasonal need and get H-2B workers. But the important thing for that seasonal need is showing work, labor tied to season, a pattern, or specific part of the year. Next, we have intermittent need and peak load need. Intermittent need is where the employer shows that occasionally there are periods of the year where needs may increase or decrease, but that it's still temporary in their services. And again, this cannot be for a specific role that is long-term or permanent in nature. You have to show that occasionally, if there's like an influx, let's say, of work or something that has now shown up, an employer is able to use this intermittent need category. Now, peak load need is a little different. Peak load need is a little easier, in my opinion, for employers to show. And this is where an employer is showing that they're having to supplement their regular workers in order to fulfill the needs of a seasonal demand or a short-term demand. And that's something I know we can all say, whether we've been in companies or have worked with companies, we see this all the time, where we have to put one worker from one area and transfer them to another because the business needs more help in that area. That's where we're going to see that peak load need. A perfect example of this would be the semi-annual sales for big stores such as Victoria's Secret, when they have these sales, this is the time where they're going to add more people because more business, the regular staff cannot keep up with the needs. And this is the perfect category for that. Now, how to obtain an H-2B. It is essentially the exact same. It's just more the time frame that matters for this H-2B. Now, with the H-2B, you have to register within 120 to 150 days before the date of need. That is very important. You don't want to be outside of that parameter because it'll be a waste of time. Next, you need to obtain that prevailing wage and submit the job order. Just like with the H-2A, you need to get that minimum wage that the employer must offer, have to get that job order submitted to show that is within parameters, while concurrently filing that temporary application for employment with the NPC. And just like with the H-2A, you're going to wait till you receive those notices that tell you when to conduct recruitment, and then you'll get right into recruitment. And then you wait for approval or denial. And then after you get your approval, you file your petition with USCIS with that I-129 and with the supplements and any necessary documents and filing fees as well. Now the H-1B. And again, if you have any questions, feel free to drop them in the chat. We will get back to you on those. But the H-1B is very commonly known throughout the United States. It is highly used. Out of these three categories, the H-1B is actually used the most. And the H-1B is another temporary non-immigrant category, but this category is specifically for specialty occupations and exceptional merit. In the occupational requirements for the H-1B is that you have to show a theoretical and practical application of highly specialized knowledge and obtaining a bachelor's degree or higher for a specific specialty as the minimum entry for that specific occupation when coming into the United States. So the threshold is, as you can see, higher and a little more detailed with the H-1B versus the H-2A and H-2B, because with the H-1B, you're having to come in and show that you can do the job before you get there fully. Now, with position requirements, as I just said, it's the bachelor's degree or having a degree requirement that is common in the industry. That is a very big thing. If you can't find one exactly, you need to find something close, but that degree requirement is what makes it fall into that H-1B category. And it is very important to know that with the position, it must be so specialized and complex that the knowledge required to perform this job is typically associated with achieving a bachelor's degree or higher. Now, to qualify for this, again, having that bachelor's degree or having a foreign equivalent to that U.S. bachelor's degree or higher. And then lastly, a great catch-all, but it's a little higher, is if you hold an unrestricted state license to practice within that specialty occupation. However, what makes this part a little more difficult for the people who want to come in on a license is that you have to be fully and immediately able to practice that coming in to the United States. So that usually comes with a few hurdles, but that is what makes the state licensing requirement a little stiffer. So it's easier to typically fall within that bachelor's degree or higher or foreign equivalent if you're seeking the H-1B. Now, the process of filing the H-1B. So the first thing that you need to do with the H-1B is determine, are you cap exempt or are you subject to the cap? Because that determines when you're able to file in essentially the filing class, so to speak, that you should be in. To be cap exempt, it means that the employer must have one of the following: an advanced degree exemption. Well, the employee would have the advanced degree exemption. You must be a for-profit company seeking to provide those services to an approved nonprofit. You have to be a nonprofit organization associated with a higher education institution or a higher education institution. These are the only ways that you can be exempt from the cap. And I know what you're wondering, what is the cap? So the cap, it's essentially for anyone who does not fall within the exemption, there's a very specified period of time in March where you must register and file, and those dates will be on the pages to follow. But the first thing for the H-1B, it's a little different, is that you have to go through that online registration, and you must indicate a start date of October 1st or later. And that's because the registration period does not begin till March for those cap subject petitions. And within that process, you'll either be approved or rejected. And it is a lottery system, unfortunately, but there are a lot of people who get chosen. Now, after that, you're accepted and chosen, you do have to go through the prevailing wage and labor condition application. And as we've talked about so far in this presentation, that prevailing wage, again, is getting that determination of what is the minimum that this employer has to pay for this position. So getting that and the labor condition application approved, just like the other processes. Once you get that approved, you're able to file that form I-129 with USCIS. And the H-1B has a validity period for up to 3 years, max 6. And it is very important because unlike other business visas where you can attach people to it, each I-129 can only name one name per petition. Each individual must be registered on their own. This is not one where you can stack on other workers onto one petition. Each individual needs their own petition. Now the timeline. Now this is a very important timeline if you're subject to the cap. The first thing is in February 21st is the earliest that registrants can start beginning to input their H-1B registrants into the online platform. March 1st is when registration period opens. March 20th at 5 p.m. is when it closes. And March 31st is when USCIS intends to notify selected registrants about whether they were accepted or denied. So what does USCIS look at when adjudicating the H-1B? The first thing they're going to look at is what duties the worker will perform and whether the employer needs the number that they're requesting. And that's just because H-1B, again, is another category that is very highly used. So USCIS wants to see, will the amount of employers that the amount of employees the employer is requesting, is it reasonable for the duties that they've outlined for the H-1B application? As well, they need to see whether or not this need exists throughout the full employment. And I do want to add, if you are an employer and you have employees in any of these categories, and there's ever a point where work ceases and it just stops, but it's still within their validity period, it is very imperative and important that you are notifying USCIS of that stop of work, because you'll just get yourself in bigger issues and you don't want your employee to have any violations occurring because we weren't able, or you as an employer were not able to sustain that work throughout the full duration of the time for their validity period. Processing time. So processing times, you're going to see if you're familiar with immigration, you're going to think these are very short, but that's because these are temporary visas. They're not meant for long term. So the turnaround time is a lot faster. With USCIS, for the H-2A, we're seeing 15 days. For the H-1B, if the visa is issued abroad, we're seeing around 1.5 to 2 months with that USCIS processing time. And we're seeing the exact same time for those within the United States as well. With the H-1B, we're seeing around 2 to 5.5 months, that being the outlier for that Vermont Service Center. And then with the H-2Bs, generally what we see is that 1.5 months to 3 months. But again, all of these numbers, even seeing this 5.5 with Vermont is great. So if you're looking for some temporary employment, this is the perfect time to start filing for these or prepare as far as the H-1B goes. And that is the full presentation on the Powerhouse visas. If you need to contact us, you can get to us via phone at 202-709-6439. You can email me. I'm not sure if my head is covering this portion that I see down here, but if you can't see the email, it's hannah.whaley, HANNAH.WHALEY @eganimmigration.com. You can also access our website if you want to look around, because we do as well offer humanitarian services. And because we're so happy that you're here and that you were able to attend our webinar, we do want to give a free gift. And it's the holiday season, why not? So we have a free consultation code for 𝐀𝐭𝐭𝐞𝐧𝐭 Webinar 3. That is the code. It is 𝐀𝐭𝐭𝐞𝐧𝐭 Webinar 3. So if you want to have a consultation or just even have some questions about other business visas, definitely go to our website, eganimmigration.com. From there, go to the business section, and there will be a section that says schedule a consultation. Click on there, answer the questions, enter the code, and it will waive your $200 fee. But thank you so much. We appreciate everyone who attended. And as well, if you want to refer back to this or share it with anyone, this will be available on our YouTube and on all of our platforms soon. But thank you so much for being here. And I hope you guys all have a great holiday season and that you guys learned so much about the Powerhouse visas for U.S. businesses.